Hello, everyone. My name is Analia Mendez, and I am the Soar Evangelist for Soar.com. I am also the Signature Career Senior Career Coach, and I am so excited to have you all present and joining us today in the webinar, Labor Law Changes May Impact You. That's the name of the webinar today. And we're excited to bring this webinar to you because I think there's a lot of important information that we all need to know as entrepreneurs, as business owners, as coaches. So if you are an independent consultant, an independent coach, if you are being hired through and on a gig basis, this is definitely a webinar that you're going to want to pay attention to. In April 2018, the state of California Supreme Court made some big changes that took the focus off of the worker and put it back on the companies who issue 1099s. And today we want you to walk away empowered with facts that you can use. And we have some amazing guest speakers today and panelists. And we encourage you, one, to take notes, definitely to jot down some questions. There will be some time at the end of the webinar for questions. Both of our experts will be answering and presenting on labor law changes, again, that may impact you. So today we are joined by Coach Timi Gleason with the Soar San Diego Dream Team. So we are so excited to have her here, and she has a wealth of experience in coaching and teaming up with different partners here throughout San Diego and the country. We're also joined by Jennifer Suberlak with Pettit and Kohn, and she is our expert attorney, and she will be speaking with all of us regarding the law changes that may be affecting not only us here in California, but different states throughout the country. So let's give them a nice welcome quietly. And I'm going to hand it over to our coach, Timi Gleason. She has an amazing story today that she wants to share with everyone. And a quiet opening, so I'm going to go ahead and hand it off to her.
Thanks, Analia. Welcome, everybody. I hope that you find a lot of value today from our seminar. I think that it's really important, even if you don't live in California, and you're going to find out it isn't just California, there's 2 other states, New Jersey and Massachusetts. But even if you don't live in one of those 3 states, this is something you should be aware of because it could affect the rest of the United States at some point. And it's also important if you're going to work with coaches in other states to be aware if their rules are different. So as Analia said, last April, the California Supreme Court changed their rules on how 1099s could be used. And it took about 5 months to sink in. So it happened in late April. And then right around the 4th quarter, companies started to realize that in 2020, things were going to be different. And so they started asking themselves, do I want to risk a lawsuit by one of my 2019 contractors? In other words, if I don't change my behavior, but my contractor knows, my 1099 knows that things have changed, could I be liable? And the question is yes. Then it was, do I want to risk being one of the first 2019 front page news stories for violation of the tax laws changes? Then can I afford to wait and see how soon the state of California is going to enforce this? And what we found was that a lot of people went, you know, I can't really wait until July of 2019 to realize that I can't run from this. I probably need to start addressing this, you know, being in compliance as of January. And then finally, how easy will it be for my company to be spotted come 2020 when the people that I've given 1099s to turn those in to file their taxes very innocently, but here is me proof that I'm not in compliance. So it became an issue that people had to deal with. So I started looking at, well, how is this a challenge for me? Because I started to see the way that I get paid changing. So my setup was that I directly contracted to people who were not coaching agencies, about 30% of my business. So if I was working for an air conditioning company as a coach or as a consultant, that was my direct 1099 work that I did. And they would be hiring me as a coach as a company that does not do any coaching or consulting. But then 2/3 of my business was team coaching. I'm on teams. And I had a colleague who had a government, a local government contract, and I was on a 1099 to her. And then I had another third party that had a 5-year government contract, and I was on a 1099 to them. And then I work for a coaching bureau, and they have over, I think they have like close to 2,000, but well over 1,000 coaches on their rosters. So I had two issues, one that would not affect me because of the law change, which was the direct contracting, and then all this third-party contracting I was doing. So let's go to the next slide. So basically what happened was when they changed the law, it was to protect people that are not paid like coaches are on an hourly basis, not even people that are paid, you know, as consultants. You know, we tend to get a fairly healthy hourly rate because we're assuming a lot of the expenses, and there's a lot of time behind the scenes and all that. But we were basically caught up in a wave. So this was geared at delivery drivers originally, and people that are paid at minimum wages or lower wages, who didn't have benefits, didn't have retirement, didn't have sick leave. And so it was a good situation that helped them, but it also was a way for California to start recovering taxes and unemployment insurance, so state taxes and unemployment insurance taxes that they don't recover right now. So there's a lot of money involved in this for the state of California, a lot of recovery of money that is being lost right now. They think about 20% or more is being lost. And then plus it provided retirement, sick leave, 401ks, and other, you know, helped minimize other abuses that were going on. But coaches and consultants were caught up in this, as were massage therapists and other service jobs that never intended, had not unionized or tried to, had not really needed anything to change. We were all perfectly happy, but no, we were caught up in the wave. So things started to change, and I started to worry. I thought, oh my gosh, you know, what is going to happen here? So here's what happened between October and November of 2018 to me. My colleague who had the local government contract, we'd had it for 6 years. She didn't want us to become W-2 employees. She couldn't be bothered. It was just a small group of people. And so she abandoned the contract. She gave it back. And so we don't do that anymore. The second one was that the government contract I have is handled by a third party. And so they decided we can't afford to have any problems either. So we'll take all of our California coaches, which was about 1/3 of their coaches, and make them part-time employees. So now, instead of turning in a monthly report, I have to do a time card every 2 weeks, even if I don't have any hours. And then the third one was a coaching bureau. And this coaching bureau decided that they were going to convert all their coaches to W-2. They weren't going to wait for it to go state by state. They were going to just say, if you would like to continue to coach with us, we're converting everyone over to a W-2. And it was interesting because they lost 40% of their coach roster. 40% of the people in the United States didn't want anything to do with it. So that was kind of interesting for them because they had all this work to do to convert it over, and then they lost their roster. So here's what the language looked like, just to give you an example with this coaching roster. You know, they're basically saying, if you want to continue with us, this is what you have to agree to. So regardless, it says, regardless of your business entity type, which could be sole proprietor, LCC, subchapter S or C type corporation, if you are a U.S. coach who is required to file U.S. income taxes, and if your company employs less than 3 W-2 employees, which most of us don't employ any W-2 employees, you must be a W-2 employee of our company in order to perform any work for us. And this is effective January 1st. So in November, we were having to make these decisions. I'm in the middle of 3 contracts with them. It wasn't going to work for them or for me to say no to this. So the question becomes, are these changes ruining things? And definitely there are some problems. The first thing that happened to me was in December. I had done a webinar, and I attracted the attention of a highly coveted company that was a tremendous honor. And they reached out and said, we'd really like you to come on as one of our exclusive coaches. And I was going to be helping to carry on a legacy of someone, and I really wanted it. And the thing was, they were in Connecticut, and they work with 1099 contractors. And so when I sent them my bio and stuff, it finally hit me, oh, I probably am not going to qualify to do this. And so I said, California just changed its laws, and I can't really do a 1099 with you. And the response was, well, we're in Connecticut. And I said, but I'm a California coach. And so it didn't happen. We both kind of walked away from it. It was very disappointing. Jennifer and I were on a conference the other day, and the attorneys made a joke about just don't hire anybody from California. That was their way of getting around it. So next slide. So, how did this happen? What can I do to protect myself and uninformed clients? Could this be reversed later? Is this one of those things where you just fake it for another year and you wait and see? Why don't more people know about it? A lot of people don't know about it, or they know about it and they don't want to know about it and they're ignoring it. And which other states are impacted? So that's why I've invited Jennifer to talk to us. So let's ask our HR attorney. Jennifer?
Thanks, Timi. Well, thank you all for joining us today. As Timi mentioned, I am an employment attorney, and that means that what I do all day long is handle issues that come up between a company and the people who work for that company. And most of the time, my client is the employer, the company, the hiring party, not the worker. But Timi and I have discussed these issues at length with respect to coaches, and that really prompted me to adjust my perspective, and instead of thinking about this just from the company's point of view, to think about it from the worker's point of view, and think about how this new case from the California Supreme Court may have actually made things a little harder for some workers, even though they were legitimately doing what they thought was best and was going to help a lot more people. And so, like Timi said, with that objective in mind, we were trying to think of some of the questions that people might have about this change in the law. And so as Timi left off, which other states are impacted? Well, we're all in California. Well, I'm in California. I shouldn't speak for everybody. I'm in California. I'm definitely affected. Workers in California are definitely affected. But what other states could this California court ruling impact? And so I'm going to jump in to answer that question first. And, the answer is, this California case can, in fact, have an impact on other states. Now, strictly speaking, California court can only create law and impact what goes on in the state of California. But a lot of states look to California for guidance on a number of labor and employment issues. And in fact, this Dynamics case, that's the case we're talking about that came out last April. This case is already being used as a point of reference for a number of pending class action lawsuits and settlements. And some of these have even been in the news. I'm sure all of you have heard about these huge lawsuits against companies like Lyft and Uber by all their drivers who are being classified as contractors, as 1099, and who are now suing in these nationwide and statewide lawsuits saying you misclassified us. And many people are concerned that because of the breadth of this new test and the impact that it's already having on these other settlement discussions, that this ABC test, which is set forth in the dynamics case, will be adopted wholesale in other states. And the reality is, in fact, a number of states already use parts of or the entirety of this ABC test for certain narrow issues, like, for instance, figuring out if a particular person is entitled to unemployment benefits. So we've already seen that the ABC test is out there in other states. And it is, in my opinion, it's likely that it's going to continue to be so, and even more so in the future. All right, so before we get really deep into what these changes in the law are, I wanted to give you a bit of legal background real quick. So on the one hand, we're talking about 1099 workers who are technically called independent contractors. And then on the other hand, we're talking about W-2 workers who are technically called employees. And legally, there are distinctions between 1099 workers and employees. And I'm going to try to stick with the term 1099 worker because I think most people understand what that means more than when I say independent contractor. But let's look at what those distinctions are. Generally, the law treats an independent contractor, a 1099 worker, as somebody who's running their own business. This is, somebody who holds themselves out as being a company of their own, even if it's a company of one, and they enter into contracts with other people or companies, and usually those contracts are for a particular period of time or for a particular project. And because you're running your own business, you are responsible for paying your taxes, contributing to Social Security and Medicare, things like that. Meanwhile, an employee is somebody who's working but is not running their own business. They're coming in every day, someone's giving them instruction, but they're not calling the shots. And in that situation, your employer will take your taxes out of your paycheck for you and send them directly to the IRS or whatever state agency they should go to. And then additionally, employees are entitled to certain benefits and protections that 1099 workers do not get. For instance, employees fall within the purview of wage and hour laws. And those are the kinds of laws that say once you've been working a certain amount of hours a day or a certain number of hours a week, you start getting overtime. Or anti-discrimination laws. Usually those only protect employees, not 1099 workers. And employees are also entitled to things like health insurance under the ACA. If the company is big enough, you can get workers' comp benefits if you get injured on the job. You can get unemployment benefits if you've been laid off, things like that. And because the labor law changes that we're discussing today will result in more workers being classified as employees instead of 1099s, I did want to touch briefly on those technical differences before going forward. All right, so that's our background. Let's now talk about the old way of doing things. And again, we're going to focus on the law in California. But just so you know, the test, the old test we're going to be talking about is the Borrello test. It's actually fairly similar to the tests that would be applied in other states, but I am going to focus on Borrello and California law. All right, so Borrello. You may be asking why there is a picture of a pickle on the slide. Well, the reason is that the Borrello case actually had to do with pickles, or more specifically, it had to do with the people who harvested the cucumbers that were later sold to pickle factories. But mainly, I just thought that was a cute picture. So in the Borrello case, the Borrello company grew cucumbers, and so every year they needed people to come and pick the cucumbers. And that way the company could sell them to Vlasic and whatever other pickle companies out there. And Borrello hired these farmers as contract workers on a 1099 basis. And long story short, the state fined the company because in the state's opinion, these workers were improperly classified as 1099s when they should have been classified as employees. And the case went all the way up to the California Supreme Court, which then articulated this so-called Borello test. So let's take a look at what the Borello test is. And this is the test that we used to use to figure out whether somebody is 1099 or employee. Now, as you can see, I'm going to toggle back and forth between this slide and the next. As you can see, there are a lot of factors under the Borello test. And I'm actually haven't even listed all of them. This is the main ones. There are additional factors I didn't include that are kind of less important, and there's also nuances to these factors that I did list. But I'm focusing on the main ones. And again, as I mentioned before, other states are going to be looking at these similar factors. So if you're not in California, odds are the courts in your state are going to be considering similar things. But what I want you to take away from this list is the first three factors, which I've highlighted in red. The first one being whether the hiring party has the right to control the manner in which the work is performed and the means by which the work is performed. So this is the number one consideration in figuring out whether somebody's 1099 or an employee. And the bottom line is, if that right to control is present, then you're going to have an uphill battle arguing that you're not an employee. So the right of control suggests an employment relationship, not a contractor relationship. And if that right of control, whether controlling the manner and the means of the work, if that right of control is absent, then you actually have a good shot of arguing that, yes, you are properly classified as 1099. All right, and then numbers 2 and 3, I kind of see them as different shades of the same color. Whether the worker is engaged in a business that's separate from the hiring party's business, and whether or not the work is part of the regular business of the hiring party. Those are kind of, I feel like those are two things that kind of say the same thing. These are the three, I think, most important factors under this test. And generally, in order to, use this test, the way you go through it is you go through factor by factor and you see how, which way it goes. And you're like, on balance, it looks like you're a contractor, or on balance, it looks like this person's an employee. Okay. So that's the Borello test. So that's the old test. And key things to keep in mind about this test is this was the test for like 40 years. Okay. And it applied regardless of industry. So even though the case itself arose in the context of farming, it applied beyond just farming. So this was the test everyone had to use to figure out if you were allowed to be a contractor. All right, and before moving on to the new test, I wanted to take a look at how the test in this case was actually applied to give you an idea of how a court examines the factors and how you might want to consider these factors if you're trying to figure, if you were trying to figure out how to use the old test, okay? So I'm not going to focus on all the factors because, again, so many. But some of the key things the court looked at were, okay, these farmers signed contracts that said they were 1099s. And so the company in the case said, hey, they have a contract that says they're 1099, we're good to go. And the court said, nah, you know what? We don't really care so much what you put down on paper. We care what it looks like in real life. So we're going to go through and look at all of the facts and circumstances to see what's really going on here. So while I would definitely recommend anybody who's trying to have a contractor relationship have a written contract that says you're 1099, it's not going to seal the deal when push comes to shove. All right. Another thing the court looked at was that it was up to the workers to figure out when to harvest a particular patch of cucumbers and which specific tools to use. And the fact that those workers were making decisions about how to do the work and when to do the work suggested that maybe they were 1099. In contrast, if you're somebody who has to follow company rules or guidelines, that suggests that you're going to be an employee. Additionally, the farmers brought their own farming tools to do this work. They brought gloves, they brought shears, things like that. That also suggests a 1099 relationship. So in another circumstance, maybe in the coaching context, for instance, are you allowed to use your own computer? Do you have to show up at their office and use all of their supplies and use all of their materials? Or do you get to create and use your own? Because if you're using the hiring party's stuff, that suggests you're an employee. Also important was the fact that the company was setting the grading standards and the prices for the cucumbers. So even though the farmers got a share of however many cucumbers were sold, they got a percentage of the price, they weren't setting the price. So that was a lot of power that the hiring party held that they did not hold. And so that suggested an employment relationship. So things to keep in mind in other contexts are you setting your own prices? Are you setting your own rates? Or are you being dictated to about how much you can charge? And do you control your own content? Things like that. Last but not least, it's pretty hard to escape the fact that in order to sell cucumbers, you first need to pull them out of the ground or however it is they grow, but somebody has to harvest them first. So harvesting the cucumbers is part and parcel of that business. And therefore it was too difficult for the employer to argue. It was not credible for them to argue that they had a different line of work than the people they were hiring. So the court concluded, yeah, these people, they're employees. And in other contexts, for instance, take Uber drivers. These are people who supply their own car, they buy their own gas, they choose whether or not they want to pick up a particular ride, but all of the rates are set by Uber. And, that's the prices are set by Uber. That alone is a lot of control retained by the company. And so in the case of Uber and Lyft workers, they have been arguing that, yeah, I don't have a lot of say in what I do. And so I should not have been classified as a 1099. I should be classified as an employee. So that's, those are the two big companies right now that are really getting hit hard with these kind of lawsuits where workers are contending that you have misclassified us. I should really be an employee. Okay, so that was the Borrello case and how it works. The reason that I wanted to share that with you was so that you would be able to tell in the future if somebody's still using this old test. I'm going to tell you about the old test and then tell you about the new test so you'll know both. And if somebody is using the old test in trying to figure out your relationship, you'll be able to tell them, actually, hang on a second, I think you're not doing that right. Let's talk about doing it this way. And then also some of these factors you'll actually see in the new test anyway. So I think going over the old test will help you understand better how the new test works. So that is why we're talking about that. Now, the thing about Borrello is that it was not a super popular test. Obviously, with all these factors, it's a pain in the neck to use, and a lot of the time people were honestly guessing about which way they should have turned out. And frankly, a lot of people were being exploited under this test because it leaves a lot of gray area. And so there are a lot of people who, honest to God, should have been classified as employees who were being classified as contractors. A lot of people in like manual labor. It happens a lot in the farming industry, manufacturing, things like that. These people were truly being exploited. And so we saw a bit of a movement of legislatures and courts trying to extend protections to capture these workers so that they could enjoy the benefits of being an employee. And so in line with that, we now have the dynamics decision. Now, this is the case that changed the way we figure out whether somebody's 1099 or an employee. And this, as Analia mentioned, this is a case that came out from the California Supreme Court last April. And in this case, it involved truck drivers who worked for a document delivery company. And basically these folks spent their whole day driving back and forth, dropping off documents. And for a long time, they were classified as employees. And some executive at the company had the bright idea one day that, hey, if we reclassify these folks as 1099, we'll save a lot of money on overtime and reimbursing them for their gas and paying for benefits. And so pretty much out of the blue one day, without changing any other aspects of the relationship, the company reclassified all the drivers to be 1099. And so they were understandably not happy about that, the drivers. And so they showed their displeasure by filing a class action lawsuit. And sure enough, the case made its way up to the California Supreme Court, which established this new test, the ABC test, for figuring out whether somebody is a contractor or an employee. All right, so let's take a look at the ABC test. So right off the bat, you can see that it's a 3-part test. And right there, that is a lot easier to deal with than the multi-factor Borello test. So on the one hand, that's a plus. Seems like it's easier to use. On the flip side, the challenging part about the ABC test is that you have to meet all 3 parts of the test in order to be properly classified as an independent contractor. So that means that if you miss any one of these prongs, you're an employee, period, end of story. All right, so these are the 3 parts. We're going to look at each part separately and chat about them. So here's prong A. In order to be properly classified as an independent contractor, the worker has to be free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for performance of the work and in fact. Now, as you might remember, this looks pretty familiar to us because back in the Borello test, this is basically the first factor. There's nothing really new here. In fact, the only thing it adds is that it puts right into the test that whatever you say on paper in your contract has to match what's going on in real life. And if you don't match those things up, then you're not showing us that you should really be 1099. You should be an employee. And some circumstances that might indicate the existence of the right to control include things like setting your schedule, specifying the materials or methods or processes you have to use in doing your work. So for instance, in the coaching context, do you have to do a debrief in a particular way? Do you have to use a particular kind of assessment? And then things like having your performance reviewed. That's typically something that a boss does with an employee. With a 1099 person, usually all you care about is the end result. Did you do whatever it was that I asked you to do? And if not, then redo it. But otherwise, I just care about the end result. So these kinds of focuses on how that work is being done, those things tend to show that there is control being exhibited. And that's a problem if you want to be 1099. All right, so that's part A. Let's look at part B. Part B says that in order to be properly classified as 1099, the worker has to perform work that is outside the usual course of the hiring entity's business. Now, I got to tell you guys, this is where most companies and workers lose out on this test. It is really hard for a lot of people to satisfy part B because it's pretty black and white whether or not you're doing the same thing that the company's doing. And this prong of the test essentially requires that the contractor's job has to be completely separate and distinct from what the company does, almost to the extent that you got to be in like a separate industry. So for instance, if you own a coaching business and the point of your business is to provide coaching services to people, and you're looking to hire a coach who's going to be providing coaching services to your clients, that person is not going to pass part B. That person's probably going to have to be an employee. Some other examples that the California Supreme Court gave us to show whether or not part B is satisfied included for instance, a bakery that has some broken pipes and needs to call in a plumber to fix the pipes. All right, well, the bakery is in the business of making baked goods, not in the business of plumbing. So that plumber is properly going to be hired as an independent contractor. But if the bakery decides to hire a cake decorator, well, I don't know about you, but I've never been to a bakery that didn't have a cake with some kind of decoration on it. So if the bakery is going to try to argue that that cake decorator is an independent contractor, they're going to have a lot of trouble getting past prong B, because the bakery pretty much is in the business of making fancy cakes. So I think for a lot of people, overcoming Part B is going to be the biggest challenge. All right, Part C. This basically says that the contractor has to have their own business. So in order to be properly classified as 1099, the worker has to be customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So that essentially tells you that whoever you're hiring has to be in business for themselves, which is fine, we knew that, but they have to have a history of being in business for themselves. And essentially they have to have been doing this for other people. So important things to ask with respect to Part C are, does the contractor, does the 1099 person have their own business? Do they have a business license? Are they incorporated? Are they an LLC? Do they hold themselves out as being a business? Like, do they do advertising and marketing? Do they have other clients? Because if all of your business is for one client, that starts looking like an employee who works for the employer day in and day out. So that is the last part of the test. And again, as I said, the most challenging thing about the ABC test is that you have to hit all three, and missing any one of them makes you miss out on the opportunity to be an independent contractor. And so, you know, understandably, there have been a range of reactions to this new test. And not surprisingly, the people who are doing the hiring are the most concerned about it, because frankly, look, there are negative consequences for all parties involved if you're getting the relationship wrong, but the bulk of those consequences are going to fall on the person who was the hiring party. And most of what you're going to have to worry about is a potential audit, and, you know, fines and penalties, because as Timi mentioned at the beginning, the state and potentially federal government are missing out on a lot of revenue that they might not otherwise, you know, they might not be receiving if people continue to be classified as 1099. You also might have upset workers like the drivers in Dynamics who, you know, felt like they were getting screwed out of overtime and benefits and, you know, meal breaks and reimbursement for gas and, you know, business expenses that their employer should have been paying for. And at least in the state of California, when an employee sues for things like that, they can recover those wages and those benefits going back 4 years. Now, in other states, it might be 2 years, it might be 3 years, but we're still talking years. And especially if you're getting hit with a class action lawsuit, that's 4 years for each person in the class. And I'm sure, I mean, there are some coaching businesses that are big and have big rosters. Like Timi said, you know, when you're losing 40% of your roster because you have a nationwide firm that has, you know, tons and tons of coaches, that tells you there are some businesses out there that have a lot of people, and could get hit pretty hard. And not only that, you know, the uncertainty as to whether some of these consequences might befall the company could be damaging to morale. And then in California in particular, owners, directors, officers, managing agents of companies can also be personally on the hook for unpaid wages. So it's not just that the company might get hit with having to pay all this stuff. They might come after people personally too. That's not necessarily the case in every state, but it is in California. And so that's another thing that a lot of these employers or putative employers are freaking out about. On the flip side, though, there are a good number of workers who are thrilled with the ABC test and the Dynamics case. And as well they should, because most of these people are people who should have been classified as employees anyway. And now they're going to be entitled to things like overtime pay and health insurance and workers' comp if they get injured on the job. I mean, if you think about it, those can be life-changing events for people. having health insurance if you have a serious disease, or having workers' comp if you have an injury. Otherwise you got to pay for that stuff on your own, and it's expensive. So a lot of people are happy with this new test, but then not all workers are happy with the ABC test, because a lot of people, frankly, want to be classified as 1099s. And there's a certain degree of freedom and independence that comes from running your own business. And once somebody tells the hiring party that they have the right to, control what you're doing, you better bet your bottom dollar they're going to start exercising that control. And so, you might have to be, like Timi said, you're going to have to be punching a time card now, and you don't get to set your own hours. You have to fit within the system now. And some people aren't happy about that. Additionally, a lot of times employers have the right to say that, hey, if you're my employee, you can't work for one of my competitors. You can only work for me, because that would create a conflict of interest. Well, if you're used to having your own clients, and, they might be in competing businesses, but what do you care? You're just providing, coaching services. You might have to lose, you're stuck with one of those. You're stuck with one client. You might have to lose some of your other clients because it would create a conflict of interest. And again, as Timi mentioned before on the seminar that we attended the other day, the attorneys were joking like, well, the easiest way to avoid this is to just not hire anyone from California, because then you don't have to deal with it. And, that might mean that if you live in California, you're missing out on opportunities to do more work. But it also means for businesses that are based outside of California that you're missing out on some talent. And one thing I did want to note is that this ABC test, the dynamics case, applies to people who are doing work in California. The general rule is that the law of the state in which the work is performed is the law that applies. So if you're in California, California law applies. If the work is being done in Texas, Texas law applies. Doesn't matter where the company is based, it matters where the worker is, where the worker's doing the work. So if you're working in California, but your hiring party or employer is somewhere else, whether it's a different state or a different country, you're still having to worry about California law. So, you might be right now in the position of being on the worker side of the equation, but one day down the line, what if you wanted to create your own coaching business and you have to start thinking about things like, oh, I have to hire people. Well, if I'm going to hire people, now I'm on the flip side of the equation as the hiring party. And I really have to start worrying about this case, because as the hiring party, I got to worry about, am I going to get sued? Am I going to get audited? Am I going to get fined? So some people are not especially pleased, because this might interrupt, some of their future career plans. And I think it's actually been really interesting that there are certain groups of workers who have been especially vocal in opposition to the ABC test. One of the most vocal has actually been hairdressers, because if you think about it, historically, that's a group of people who have almost always been 1099. And under the new test, if you're working in a salon and what you do is cut hair, and the salon offers haircutting services, then you don't pass Part B of the test. So all of them are going to have to be employees, and they're not happy about that. So, one of the questions we asked at the beginning is there a possibility that this could be reversed? Well, I'll talk about how not really, but, there is the ability for, the possibility of some interest groups obtaining special carve-outs to the law for their group. And in fact, that's what hairdressers are trying to do right now.
Yeah, and we're at 15 minutes left.
Okay, I'm just about done. So basically, you might be asking, all right, why is this happening? Can I get out of it? The reality is no, especially not if you're in California, New Jersey, or Massachusetts, which have adopted the ABC test wholesale. But like I mentioned before, there are a number of states that already use parts of this test, so that groundwork has already been laid in other states. for, even though they're using it in a narrower sense now, they might expand to use it like California and New Jersey and Massachusetts are. And again, as I talked about at the beginning, a lot of these other states are going to be looking to California as the leader in the field. And so they might feel compelled to start doing whatever California is doing. So, I mean, I think it's safe to say in the next 5, 7, 10 years that a number of other states are going to adopt the ABC test, just as California had. And so, the fact that you might not be right now in a jurisdiction that has it doesn't mean you won't be soon. And for that reason, you do want to think about, what is this test? What's the impact it has? You might not be able to take refuge in other states for a long time. And so this map will show you that the states in red are the states that have the full-on ABC test. The states in yellow are the ones that have parts of it. And that's most of the map. So I don't think we're going to be able to really escape this. The adoption of this test has definitely been part of a nationwide trend in expanding workers' rights. If you think about the national debate about raising the minimum wage, providing paid family leave, this is all in that vein. So I don't think it's going away. And so at the end of the day, the reason why we all thought this was a really important topic to discuss was that, there can be very serious implications for getting this relationship wrong. And even, as the coach, you might not be the person who is going to be on the hook for, the fines or the class action lawsuit and things like that. But do you really want to be the person who sets up your business partner or your clients to be on the hook for that? So at a minimum, this is just a list of some of the bad things that happen. And it's just important. We want to educate you so that all right, here's something I need to think about. In my next gig, I can at least, have an informed discussion with the hiring party and see how are we going to do this going forward? How do you want to do it? I just need you to know the risks, because the consequences can be grave. All right. So with all that being said, we created a brief test for you guys. Let me see. Go here. See how well you've retained all of that legal gobbledygook that I just spewed at you. Question number 1. I'm not sure if you.
I'll help you with this. So Analia, if they're talking to you in the chat box, maybe you could let us know if they're retaining what we've talked about. So we want to know the old rule. What was it called? It starts with a B. Borello. Got it. Rebecca. Good. Hi, Rebecca. This law mostly benefits, this old law mostly benefits employers or workers?
Workers.
Workers. Name of the new rule is now what? ABC. The new law is, I'll just tell you, is simpler but harder to pass or sustain, or yeah, it's harder to pass. Who does it protect? Who does the new law protect? Workers. And why do workers need protection? Okay, they need protection because they have certain rights that are not being respected. They maybe are being cheated out of money. They're being cheated out of tools, resources. And basically, this was a rule that got out of hand for a lot of people. Benefits, right? Accurate pay. Okay, let's go to the next slide. So are certain business classifications exempt from this? Not really. That's right. And not really. So would you, and Jennifer, what would you say about that? Agree?
I would agree. Yeah. At the state of the law now it goes across industries, and we'll have to stay tuned in the next couple of years to see if there are any amendments made to it. But as of right now, nope, everyone's covered, all industries.
So famous company names behind this new Supreme Court decision, and a company that started some of this when it first appeared in the news are Uber and Lyft. And as Jennifer and I learned a couple weeks ago when we were at this other seminar, you know, FedEx has been involved. And in fact, a lot of cases that are being resolved, they're going back now and looking at this just to see, you know, are there any ideas, are there any aspects that they missed? So maybe the lawsuit was before this decision, but they're now settling this old lawsuit, but they're going back now to this new decision to see is there anything where we've missed any good points here. So they're using it as a frame of reference. And of course, other states are going to do that too. As things come up, they're going to go back to this California law and look for ideas and look for angles. What not to do if you don't like the new law? Any thoughts on that? What not to do? So the first, don't ignore it. That's right. Don't ignore it. And don't say, don't poo-poo it. And don't settle when your client says it doesn't apply to us. Do the tough thing and say, let's talk about it. Let's see if that's really true. I had someone say to me, I do hire a subcontractor, but that subcontractor works in change management. We work in a different area. I said, do you both consult? And she's like, oh God, yeah, all right. So, you know, it's just, it's about the industry you're in. It's not specifically the task, like to Jennifer's example about cake decorating in a bakery shop. Okay, why were coaches and consultants included in this? Are they picking on us? The answer is no, they're not. We were caught up in a wave. We're just part of it. I was explaining this to my daughter. She lives in Portland, Oregon. And I thought it would be good for her to know because she's kind of in a related industry. And she said, oh, I already know about it because my future mother-in-law owns Massage Envies in California. And she's been telling me all about the fact that they had to take all these independent contractors and move them into part-time employees. And then I don't know if any of you saw this the other night, but John Oliver on his show late at night on HBO, he's a comedian. He did a whole 34-minute rant about wrestlers and how they should not be independent contractors. They should be employees. So if you want to really see something entertaining and also think about how real this is, go and just type in John Oliver wrestlers and it'll come up right away. It's in YouTube. Okay. So we want to know, was this information valuable? What are you going to do to protect yourself and to protect your client companies? And we also want to know if you have any last questions. I do. I want to know if you guys know what VUCA is, V-U-C-A. Because this is something I'm seeing it more and more, and you need to know what it is. Does anybody want to know? Anybody need to know?
Go for it, Timi.
All right, VUCA. Volatile, uncertain, chaotic, and ambiguous. Okay. And that's coming out of war talk, but it's being used now in private industry. So good one to know. I saw a question come up related to moving people from 1099 to W-2. Is that what it was? Is it easy? Is that what the question was, Analia?
Right. So I'm seeing here, how easy is it to convert a 1099 to a part-time W-2?
So I had this come up Sunday night. I was out to dinner with some friends. They own a company. It came up that I was doing this webinar, and my friend's in the real estate business, and she says, I know that I'm supposed to move these people into being employees, but how do I do it? Well, the part that's difficult about it is if you're not used to administering all this stuff, you're going to have to find somebody, a bookkeeper or somebody that's going to do this for you, with you, make sure it's done right. So that'd be the hardest part about it. But the question was, well, how do I do it now when here it is April? How do I do it? And I said, just tell them you just had your taxes done. that your CPA made you aware of the fact that you needed to convert these people. It was time, and that you immediately took care of it. So try to find an event to tie it to say how it and why it makes sense that you finally took care of it. And you don't, this is why a lot of people converted me over last October, November, because they didn't want to wait until the middle of this year when it became ferociously interesting to talk about it. And everybody was more aware that they didn't want to be having me 1099 for half the year and then part-time employee the rest. Any other questions? I have a question for Jennifer. You were saying that it's the state that the work's being done. And I think for me, that wasn't clear. If I'm a Californian and a company that's not regulated by ABC, a state that's not regulated by ABC asks me to go work in Texas, it isn't the state I'm doing the work in, it's the state I live in.
It's the state that you're doing the work in.
So if I go to Texas to do it and I'm a Californian?
Assuming that Texas doesn't use the full-on ABC test and that you otherwise would qualify as a 1099 under Texas law, which I'm not licensed in Texas, so I can't speak to that. But it would be, if you're working in Texas, the laws of Texas apply. If you're working in California, the laws of California apply. So
I just found a loophole. We'll do all our work in Arizona. All right. Okay. That's good. I'm glad I asked that.
So just a follow-up question, Jennifer, for the audience also. If you're working virtually, but the work is being conducted virtually, how is that viewed?
That's a great question, because that's definitely on the rise. It's still wherever you are. You know, I mean, I'm assuming if you're working virtually, but you're working from your home, probably most of the time that you're doing that, it would be where, the law of the state where you are.
Yeah.
And most of the time, a lot of the time, like say you're, even if I'm a California employee, if I go on a business trip to Illinois, I'm still going to be covered by California law, because that's just a temporary departure from my home where I'm doing my work. But if you're wherever you're living and that's where you're working, that's the law you need to worry about.
Perfect.
Yeah, that's what happened to me, right? I do all my work for the government virtually. I never meet these people in person. They're all over the world, but I was converted over to a part-time employee. And the same thing with the other coaching group that I work with. I'm doing it all virtually. So I was converted over because I'm a Californian. Okay, well, we did pretty good on our time. And we want to thank everybody for asking questions. And Jennifer, thank you so much for teaming up with me on this. It's so fascinating. You do such a great job of explaining something that could be really boring to everybody and making it really interesting. And I really appreciate your pickle cartoons very much.
Thank you, Jennifer and Timi, representing both Soar.com and also Signature Careers. And Coach Timi, thank you for sharing the information. I think this is really important. And Jennifer, we most appreciate it. I know there are a lot of people that are interested in this topic. And as careers and jobs and labor is changing very quickly because of our new technology, I think it's important for all of us to keep up with what's happening in labor law.
All right. Well, thank you all for the opportunity. And I've certainly learned a lot about coaching as a result of doing this. And I'm like, career change?
I know. It's your retirement.
Sounds a lot more fun.
Thank you, Analia, very much for hosting us. Bye, everybody.
Thank you. And if you have any last questions, please email me at signaturecareers@gmail.com, signaturecareers@gmail.com. We are recording this, so we will be able to share it after the webinar is over. And I thank everyone in the audience for attending. We hope you found it very useful.